Welcome, everyone. I'm Annie Cartwright. I'm a partner in Husch Blackwell's higher education practice. Before we begin today, I have a few housekeeping items to cover. You will see a series of application icons at the bottom of your audience console. Please submit any questions you may have during the webcast through the question box. We'll try to answer any questions during the program. If a fuller answer is needed or we run out of time, we may be able to answer later by email. And a PDF of the presentation materials is available in the program materials folder. This program has been approved for complimentary continuing legal education credit. Live attendees may report their hours by clicking the CEU icon at the bottom of the screen. A certificate of attendance will be emailed to you along with a recording of the webcast for watching and sharing. Towards the end of the program, be sure to complete our brief survey. We really do use your responses to plan future programs that are relevant to your needs and interests. Presenting with me today is my colleague, Mary Deweese, who's an attorney in our Chicago office. She was once a teacher in Washington, D.C., but she made the dubious choice to go to law school over 10 years ago and is a critical member of our education group. She works primarily with colleges and universities addressing regulatory issues, including accreditation and non-discrimination. She works in litigation and a number of issues specific to healthcare education. Again, I'm Annie Cartwright, and I am excited to be a member of our Link office, but I am sitting in our Kansas City office today. I'm happily no longer a litigator, and I focus my practice on higher education regulatory matters, most notably around student and learner funding, general counseling, and the range of issues presented in healthcare education programs. Finally, Mary and I are both members of Husch Blackwell's academic medicine team, which brings together professionals from a number of practices, most notably healthcare and education, to address those issues that lie at the intersection of healthcare and education. Today, we're going to discuss topics around which we have received the most questions in the last year in the academic medicine space. That's us. Those include non-discrimination issues, including issues around disability, accommodation, Title IX, sex discrimination, and we're going to touch briefly on accommodation requirements related to vaccination requirements, which is a constant issue recently in healthcare education. We're going to touch briefly on contractual and constitutional due process issues, especially in the area of discipline of students and learners. We will do one slide on ACGME's accreditation requirements for resident leave, which is a new requirement effective or enforced this year. We will talk about the educational considerations around sort of alternative student funding, including education for work agreements, and we'll also touch on changes of control and what that means for institutions of higher education, particularly those that are owned by healthcare institutions. So first up is our poll question for today. Based on the audience attendee list, I saw that we have a range of audience members. We see attendees who work only in healthcare settings, people who work in colleges and universities. We also see members of general counsel's office, and then people who might wear 3 different hats as an administrator of a tiny little healthcare institution. Please know we've attempted to strike the balance and hope that each of you walks away with some piece of information that's new to you. So with that, it looks like most of you are at traditional institutions of higher education, some are at healthcare only, and many of you are at combined institutions. So with that introduction, I'm going to hand you over to Mary to walk us through some non-discrimination issues.
Thanks, Annie, and good afternoon, everyone. I'm so glad you could join us today. As Annie said, we are going to kick off today's webinar by talking about non-discrimination laws. There are a lot of federal and state non-discrimination laws that apply to academic medical centers, and that's without even getting into agency regulations, local ordinances, and any contractual or policy provisions. Some of these laws apply to a specific protected category or status. For example, Title IX prohibits sex discrimination, whereas the ADA and Rehab Act prohibit discrimination on the basis of disability. Others are a bit broader. Title VII protects against discrimination on a large basis of protected categories, as does the Equal Protection Clause of the Constitution. Whether or not any of these specific laws applies to your institution, and whether or not the laws apply to your students also varies. For example, Equal Protection Clause applies to both students and employees at public institutions. It also prohibits discrimination on a variety of bases, but applies different levels of scrutiny based on the type of discrimination at issue. And these laws all overlap in various ways, meaning that, for example, disparate treatment of a student with a disability may be illegal under the ADA, even when it's constitutional under a rational basis review under the Equal Protection Clause. So in any event, the list on the screen before you is not exhaustive, and we don't have enough time today to cover each one of the laws covered here. What we do want to talk about today, though, is a few specific laws applying to students, residents, and fellows at academic medical centers, which includes Title IX, which applies to entities receiving federal financial assistance and prohibits discrimination on the basis of sex within education programs and activities at those institutions. Then there's also Title VI, which also applies to institutions receiving federal financial assistance and prohibits discrimination on the basis of race, color, national origin. Both Title IX and Title VI might apply to both students and faculty, although there's some nuance to that we're going to get into later. Title VII, however, applies to employees only. It prohibits everything prohibited by Title IX and Title VI, as well as religious discrimination. Finally, students and employees with disabilities are protected by the ADA, which applies to public entities and private employers with 15 or more employees, which is basically all of higher ed, and the Rehabilitation Act, which applies again to entities receiving federal financial assistance. We're going to talk about each of these in a bit more detail over the next few minutes, starting with Title IX. As I said previously, Title IX prohibits discrimination within educational programs and activities. Any institution which receives federal financial assistance is subject to Title IX in the education programs and activities it has. Under Title IX, discrimination is broadly read to encompass sexual harassment and sexual misconduct. An institution cannot be deliberately indifferent to known acts of sexual harassment or misconduct occurring within its programs and activities, which includes not only faculty on student harassment, but also student on student harassment. Those of you in traditional healthcare settings might be wondering, does Title IX even apply to my institution? And the answer is yes. Title IX applies to any institution receiving federal financial assistance where that institution operates an education program or activity. And federal financial assistance includes not only monetary awards and grants, but also non-monetary assistance if the government has given you land or has given you discounted rent on something. At a traditional educational institution, Title IX applies to all of the operations of the institution. At other institutions, Title IX applies to those portions of the institution which are engaged in educational programming or activities. And so the DOJ actually explained this in a illustrative example where if a private hospital has federal assistance for its emergency rooms, all the operations of the hospital, for example, the OR, the pediatrics department, admissions, et cetera, is covered by Title VI, is covered by Section 504 of the Rehab Act, it's covered by the Age Discrimination Act. But Title IX is limited only to the education or programs or activities. So at that hospital, Title IX would apply only to students and employees of the education programs operated by the hospital, if any. So this is really nuanced about when Title IX applies if you're a non-traditional, if you're not a traditional institute of higher ed. But as a general matter, it's important to know that Title IX applies at least to your education programs, if not your entire operations. And we just went through this right now. So what does Title IX require? We could, and in fact we do, provide a whole day-long training on the requirements of Title IX. For today, however, we just want to give you a very brief overview. The U.S. Department of Education, which funds many academic medicine programs, has very robust Title IX procedural requirements. This includes that when the institution has actual knowledge of sexual harassment or sexual misconduct, sexual violence, these obligations are triggered. The institution has to provide supportive measures to the victim. There's a requirement that an institution begins a investigation if a formal complaint is filed. The formal resolution process includes the formal complaint, the formal investigation, a live hearing with cross-examination, and a right to appeal. There's also a requirement for informal resolution options. What we want to note, though, is that these requirements are likely to change at least somewhat any moment. The Department of Education has proposed new regulations, which many are expecting to drop any day now. These new regulations will likely expand the application of various requirements to all forms of sex discrimination. We expect the live hearing requirement to be dropped, but that there still is going to be very robust procedural requirements. What if your institution doesn't have Department of Ed funding, however? Well, many funding agencies have independent Title IX regulations that you have to comply with. On the screen before you, there are several that commonly fund institutions with academic medical programs. Most of these require a relatively common sense approach to Title IX, although there's nuance between each of them. But as a general matter, you should have a policy prohibiting sex discrimination in your education programs and activities that everyone should be on notice of. You should give all your students, employees, residents, et cetera, notice of these policies. You should have a Title IX coordinator who everyone should know how to contact. You should have a process for resolving complaints of sex discrimination. And you should take steps to prevent sex discrimination. Some of these agencies do have more robust requirements. The National Science Foundation has specific requirements. NIH and HHS have specific requirements. Some of these requirements are changing. For example, on July 31st of this year, universities seeking NSF or NIH grants are going to have plans in place to comply with proposal and award policies and procedures guide that's titled Safe and Inclusive Working Environments for Off-Campus or Off-Site Research. We are not sure that a compliant Title IX policy will be sufficient for this. The guide seems to go beyond sexual harassment and assault and require the university to have a plan for bullying, hazing, and other unwelcome or disorderly conduct. So it's really important that you know the requirements for each agency that you're getting any financial federal assistance from. So as I mentioned earlier, the question of whether Title IX or Title VII applies to employees of an educational institution and residents in many ways are employees, not necessarily traditional students. This question is quite nuanced. There is a circuit split as to whether Title IX, Title VII, or both laws apply to sex discrimination in employment within an educational program. And this is important because the key consideration is whether Title VII preempts Title IX, meaning that in order to bring a claim for sex discrimination, the employee must comply with the requirements of Title VII, such as filing an EEOC complaint. Title IX does not require that process. So in some circuits, for lack of a better term, you could bypass those procedural requirements of Title VII by filing a Title IX complaint. In other circuits, you can't do that. Title VII preempts Title IX. So Doe v. Mercy Catholic Medical Center is the most on point one of these cases. This is out of the Third Circuit. Therein, the Third Circuit found that a medical resident could bring her sex discrimination claims under Title IX, therefore skipping the administrative remedy requirements of Title VII. Other courts have found preemption or no preemption in different cases not specific to residents. So over the next couple of years, it'll be really interesting to see how this plays out. It is likely going to be resolved by the Supreme Court eventually. So in addition to Title VII and Title IX, your institution may have its own policies and processes in place to address sexual misconduct. sexual harassment that falls within the definitions of Title IX must be responded to using your Title IX policy. However, other forms of sexual harassment, for example, sexual harassment that is not severe or pervasive or that occurs outside your programs and activities, could be addressed through other standards of conduct or similar policies. We do want to note that under the new Department of Education regulations, however, there might be less room to use these other procedures because we expect that the scope of what is sex-based harassment under Title IX will be expanded.
Mary, we have one of our first questions, and I think this is a good place to address it. It's, if you have a resident who alleges sexual harassment, can you address that under Title VII instead of your Title IX policy?
Thanks, Annie. So I think the answer here is it depends. A resident is both a student and an employee. Resident is usually engaged in your education programs and activities. If the alleged misconduct occurs within those programs and activities and your institution takes U.S. Department of Education dollars, you have to follow the Department of Ed's regulations, which would require some implementation of your Title IX process. If you don't take ad dollars, you probably have more flexibility in what process you use. That is, most other agencies, as we discussed, only require that you have some process in place, which could be the same as your Title VII process. If those policies are, if your processes under Title VII and Title IX are the same, it's likely best to document that you're following both processes. And of course, as I talked about earlier with the Mercy Medical Center case, this might vary by circuit based on whether you're the resident that has a legal claim premised under Title IX or Title VII against your institution, which is different than whether you should respond using your institution's Title IX or Title VII policy when that resident brings concern about sex discrimination. So it's really nuanced. And I know lawyers love saying that, but we advise you ask your counsel for further guidance on that one. Just wrapping up the Title IX section quickly before I turn it over to Annie, we just want to make sure that you also consider how pregnancy, nursing, and parental status are implicated by Title IX and any other federal and state laws. There are a lot of them that govern these statuses and require that you properly accommodate these people when they're in your programs. So just know that Title IX is pretty broad and can cover a lot of these, including that we anticipate that parental status will be addressed in these new Department of Education regulations. So I'm now going to turn it over to Annie to discuss the ADA and the Rehab Act.
Thank you, Mary. And we are on to our next poll question. It is, are you familiar with your institution's process for granting accommodations to students or to learners? And we get tons of disability accommodation questions in healthcare settings, largely because as an institution of higher education, you don't have control over your clinical site. And there's some nuance between accommodation of students and learners and accommodation of employees. And not everyone is really even aware what an accommodation is or that it needs to be granted. So often we'll see clinical sites that may misstep, and then institutions of higher ed need to help get the student or the learner what they need. And going on to our results, thankfully, most of you are aware of the process, so thank you for that, and good job, institutions, for publishing those. So we have Section 504 of the Rehabilitation Act. It says that any recipient of any federal financial assistance from any federal agency is prohibited from denying qualified individuals with disabilities education or training or employment. It applies to private organizations who are engaged principally in education or healthcare. It protects across the spectrum of covered entity activities. A qualified person, and this is usually the hook, similar to the hook for Americans with Disabilities Act, is someone who meets the academic and technical standards essential to admission or participation. And wherever possible, we are supposed to adjust our requirements to meet the needs of individuals with disabilities. In almost all cases, as with the Americans with Disabilities Act, this calls for an individualized assessment of a learner request for accommodation. There are a bunch of cases out there that say that having a condition that jeopardizes patient safety can render an individual unqualified. The ADA is similar. Many of the issues that arise under asking whether someone is qualified under the Rehabilitation Act under Section 504 go to the question of whether a requested accommodation is reasonable or poses an undue burden under the ADA. So essentially, we end up with the same outcome, regardless of whether 504 or the ADA applies to you, but the process and the language we use around it is a little different, or at least the language the courts use around it is a little different. The ADA applies to public institutions in education, pretty much all institutions in employment, and to the extent they qualify as places of public accommodation, just about everyone is covered. What is a disability? It's an impairment that substantially limits a major life activity. Keep in mind that major life activities has a very broad definition. It includes things like learning. It can include things like getting places on time. And so generally, it's pretty rare that we're asking whether an alleged condition is actually a disability. Usually we're more focused on the process that applies to resolving the disability accommodation claim. We always want learners who are adults to self-identify and let us know that they have a disability and they are requesting an accommodation. People are certainly entitled to privacy. And then we can ask them for documentation about that. And then we go through an interactive process. This is not one size fits all. And we make reasonable accommodations on a case-by-case assessment of what is reasonable considering the student's program, for many of you considering patient safety, and other aspects of that are relevant to whether an accommodation is reasonable. We get a lot of questions around documentation. What kind of documents can we ask for? The reality is that we highly recommend that you do ask for documentation from a licensed medical provider who is treating that individual. So something from mom is usually not acceptable as much as mom might prefer otherwise. Again, we require students to self-report, and the documentation we request generally needs to be current. For a lot of you at traditional institutions of higher education, students will be used to the K-12 process, which places a much higher burden on institutions to run this process and create evaluations and documentation. Here, the burden is on the student or the learner to produce the documentation. And you can ask questions of those treaters. We don't want to overly burden students and learners, but we can certainly ask them questions. And sometimes we can ask their treaters questions. What we don't want to do is be asking for a general medical release for all of their health records. Use particular sensitivity and care when you're asking for campus-held medical records. There are some nuances around FERPA and disability accommodation guidance where we really want to use care to make sure that we are not sort of grabbing that information as a shield as opposed to supporting students in making the accommodation. And then what a reasonable accommodation is going to depend. There we are again, shockingly, on a Husch Blackwell webinar, we're saying it depends on the circumstances. Common accommodations are things like extensions of deadline, more time for work. Since COVID, we have seen lots and lots and lots of accommodation requests to do online learning, and whether that is reasonable is going to depend on the circumstances. Notably, learners are not required to get the accommodation they request. Sometimes they will get some sort of hybrid version or something else. They don't need exactly what it is they're requesting. We've seen some requests for, say, can I participate remotely from Tennessee in a clinical program that you're hosting in California? The answer to that might be yes, but it also may well be no. And it is okay to deny accommodations if they fundamentally alter your program, if they are basically not going to provide the information that a student really needs to complete this program. Something relevant to many of you is whether the student really needs this information to work in their field. Nurses I'm a huge fan of you, but you are often sticklers when it comes to broadly defining the fundamental nature of your program. Be sure to carefully consider what is really required for a student to become, say, a nurse or a CNA. Is it really true that they can't be in a wheelchair? Is it true that they must be able to lift 100 pounds when what they're looking to do is to be a preschool nurse or something like that? So be careful as you're defining your academic requirements. In the employment setting, of course, the standards are a little bit different. You don't need to accommodate someone in a way that conflicts with the essential functions of their job. Undue hardship is easier in the employment setting when you're doing an employment disability accommodation analysis than when you're doing an educational disability analysis. Courts have generally, and this is broad strokes, held that financial hardship is a super, super high bar at institutions of higher education. So simply because a student with a hearing disability needs a sign language interpreter throughout their 4-year program, and that interpreter is going to end up costing your institution 3 times what the student will pay in tuition, that alone is not considered commonly an undue financial hardship, because the courts look at the full spectrum of your budget and what impact that it would have on that. Direct threat is really relevant in health and safety. In healthcare programs, especially around COVID, we've seen a lot of discussion around that, or something that creates an imminent risk to the student's health and safety. You also don't need to create those accommodations for students. There is case law, and much of it is from sort of the early 90s and late 80s around HIV, when we were still sorting out the implications of HIV and managing HIV, that says that a student who has some sort of bloodborne illness does create a direct threat to patients and therefore can be denied a reasonable accommodation. Of course, I don't think those cases would still be applied in HIV situations, and you would still need to go through a case-by-case assessment of what the student is doing and how the HIV can be managed. But they are instructive when you're thinking about where that direct threat border lies, especially when we're thinking about things like COVID vaccination, which we'll touch on a little more in a moment. Examples of reasonable accommodations are things like, can we give the student a priority registration? Do they need assistive technology like captioning? Do they need extra time on exams? For rotations and clerkships and clinicals that have overnight requirements, you might consider, can you reschedule them? Can you give them an assignment that has less standing? Sometimes you might need to give them priority selection of clinical spots. I know that's a thorn in the side of a lot of healthcare education programs, because a student can assert a disability and therefore get sort of a primary clinical spot or a preferable clinical spot. But that may be what we need to do. Again, depending on the facts and circumstances of the student situation, sometimes having a disability means there is some benefit that other students will exchange in order for you to be able to make that disability accommodation. When you're determining that a disability accommodation is not reasonable, there is case law that outlines what's not reasonable. So providing a staff surrogate to meet patient care needs, that's not something that needs to be done. We have a local University of Kansas case on that from the 10th Circuit. You don't need to waive requirements to pass licensing exams. If passing that licensing exam is part of the requirement to becoming a physician in this case, and your program is designed to place licensed physicians, we have one case, again, from the 10th Circuit saying that you don't need to make that accommodation, or allowing partial completion of curricula, especially clinical sites, or waiving some other essential component or task that a healthcare provider needs to be able to provide, like CPR. Consider whether your stated requirement really is a requirement of your program. My favorite case example here is Palmer College of Chiropractic versus Davenport. In that case, a chiropractic student had asked his institution for a reader for x-rays. And the institution felt strongly that a chiropractic student needed to be able to read x-rays, the student was blind, I should share that with you, because they said you've got to be able to read an x-ray in order to be a chiropractor. And in a lawsuit case, the student produced evidence showing that a lot of chiropractors actually use radiologists to read their x-rays, and that you don't have to be able to read an x-ray in order to be a chiropractor. And the student prevailed on that. And part of his damages was reimbursement for the reader that he had hired to escort him through the program. So keep in mind, we really have to be careful when we're considering what a fundamental alteration of the program is.
Annie, we're getting...
Go ahead.
Sorry to interrupt. I was going to say we're getting a lot of questions in actually having to do with how to balance patient safety with student accommodation. So can you tell us a little bit about what we do or what the school should do when there's a conflict between a patient care need or a patient safety concern and a student's accommodation needs?
Sure. So safety first. That's been ingrained in all of us for a long time, and it's typically the approach that healthcare institutions take. Understandably, I would rather risk a disability lawsuit than some sort of harm to patient or others around a student who's been given an accommodation. We want to do that case-by-case analysis. Is the requested accommodation really a fundamental alteration of our program? Is it really causing a direct threat? Is there a way we can still get the student the information they need in a way where they're not posing a direct threat to patients? For example, in the academic medical center, we've seen students who might request a later rotation time, and it's posited that rounding later might impair patient safety because being part of the rounding group is critical in terms of patient communication, and it would be too disruptive to change the rounding schedule. Consider whether that's really the case, whether patient procedures really need to take place at 7 o'clock in the morning. It may be that they do, but be sure you're making a fact-specific analysis there. And again, remember, students aren't necessarily entitled to the accommodation that they ask for. You can try to craft some other reasonable accommodation that would meet patient safety needs as well as student accommodation needs at the same time. And I say that realizing it's very easy to sit here and tell you that. It's much more difficult to implement it on the ground. What about misconduct? You can still discipline students for misconduct, even if that misconduct stems from a disability. There's a case here against Nova Southeastern, and the case explained that where a student had depressive episodes that caused him to abuse alcohol, fail classes, and withdraw from his studies, he was not otherwise qualified. And therefore, he was not, and he didn't have a disability claim. He didn't meet that Section 504 requirement. Again, otherwise qualified is someone who, with or without reasonable accommodation, can perform the essential functions of the job or meet the program's academic technical standards. If you are abusing alcohol on the job, you are not meeting technical standards or meeting the essential functions of the job. Now we'll turn a little bit to vaccination. We've had lots of questions about requirements around vaccination. When it comes to vaccination and civil rights, we see two key areas where students are requesting accommodation. That's religious accommodation and disability accommodation. Also, sort of a subset of that, or a corollary to that, might be a medical accommodation where someone doesn't have a disability. Let's say they're pregnant, which is not in and of itself a disability, according to the courts. But there still may be medical reasons why a physician suggests that someone not receive a particular vaccination at the time. So that would be a medical accommodation requirement. I'm not going to read you this very detailed chart. It is there for future reference, and it relates to the various laws that explain when a disability or medical accommodation is required and when a religious accommodation is required. So long as non-discriminatory exemptions are provided, we've seen case law that says students don't have a right to refuse to participate. They do, according to many courts, understandably have a right to refuse unwanted medical treatment, but that does not necessarily mean that they have a right to participate in your clinical programs if you're following your appropriate exemption processes for things like religious and disability accommodation. There is some case law that says where you demonstrate a public health need for a vaccine policy, and the policy generally applies to everyone, we're having courts uphold policies, in part because students often have alternatives like applying for exemptions or maybe deferring enrollment or transferring to another institution. There's one recent case from New York. It's February 2023, and it grants a defendant's motion to dismiss. That means a student brought a claim against a healthcare entity saying, as a former medical resident, that when the healthcare entity cited undue hardship in refusing to grant her medical and religious exemption from COVID-19 vaccines and treated her employment, she said they were discriminating against her. And what the court said in dismissing that claim is that the risk associated with an unvaccinated employee providing direct patient care was, the system had established in this motion to dismiss, an undue hardship. And because the Second Circuit had already held that vaccination was a proper condition of employment, she failed to show that she was qualified for her residency position. The court also dismissed sex discrimination claims because she was pregnant, and ADA discrimination claims because the court said she was unable to allege that she was otherwise qualified for the condition without being vaccinated. Some things to consider as you're applying your vaccination requirements is this really a request for disability or religious or pregnancy or medical accommodation, or is this a personal preference? Sometimes learners will not articulate the basis of their accommodation request or exemption request. And if your policy requires people to be vaccinated, absent some granted exemption, our recommendation would be that you remind them of your accommodations process, but we're not aware of any case law that requires you to grant an exemption simply because someone does not want to be vaccinated. Consider the intersection of college and university obligations versus your clinical site requirements, which you are always doing, of course. The case law is unsettled here. These cases, as you saw in this motion to dismiss that was just issued in February, are just starting to hit the courts. It would have been lovely to have them about 3 years ago, but we didn't. And so we're still finding out what the courts, jurisdiction by jurisdiction, are going to say about vaccination, and try to balance those factors, just like you would in any other case-by-case analysis. Consider whether there's a way you can grant the accommodation to still get the student, particularly in clinical sites, the information that they need or the educational experience that they need. Employee accommodation, I think you're all familiar with what that looks like. For students, that can be those employee type accommodations, but they also might be the option for remote work. That's easier in didactic courses than it is in clinical site experiences. Consider that as educational institutions or residency programs, you still have a duty to meet accreditor requirements for quality education. I'm not sure what ACGME would say about having a resident work remotely. That could probably cause issues, so that may not be an appropriate accommodation, but maybe there are parts of residency obligations that could be done remotely. Maybe paperwork could be done remotely. Courts often defer to academic judgment, but be careful because there are times when courts will examine these disability placement or disability accommodation issues and find that they will sometimes second guess a school or an educator. We have seen a few cases recently hit the ground about healthcare institutions refusing to grant students accommodation in addition to that one that I just discussed. Again, they seem to just be hitting the courts. One of the recent cases against a school in clinical in Tennessee said that the school would not allow the student to attend clinical experiences without vaccine, despite one hospital telling her that she could obtain an exemption. And I've seen this a few times, especially in nursing programs. A student will call your disability accommodation office and say, well, I called the hospital and they said I could get an exemption. That might be the case. But I think more often it may be a case of the person who answers the phone thinking about the employment context, and particularly where you just have a visiting student. So your clinical site doesn't really have a contractual obligation to the student. It may be that the clinical site will not make an exception for students, even though the person who's answering the phone was willing to make one for an employee and was thinking about it in the employment context. But at the same time, I think you do have a duty to at least try to find a clinical site that would allow someone to proceed with their program without being vaccinated. And with that, I'm handing it over to Mary to talk about due process and learner discipline.
Right, thanks, Annie. So due process is both a constitutional idea applicable to our public institutions and a contractual idea. For our public schools, the key consideration is whether a student has notice and an opportunity to be heard prior to being suspended or dismissed from a program. The level of what being heard is or is not varies by the type of discipline. For true disciplinary matters, a full hearing is often required, whereas for an academic dismissal, someone who is suspended or dismissed or held back for a year, asked to repeat a course, it's likely sufficient just for the student to have noticed that that's happening, and then an opportunity to explain him or herself or provide a response in a much, much less formal manner than a full hearing. At all institutions, however, whether public or private, the process involved for student discipline is governed by your policies and procedures. This includes your student handbooks, your residency agreements, and anything else you have that sets out some process for discipline, whether it's for academic reasons or purely non-academic reasons. It's really important that you follow what your process says. And finally, we want to note that you should be aware of what your accreditor requires. For example, ACGME requires that residents be given ongoing feedback, formal evaluations, and documentation of any performance issues prior to any sort of academic discipline. Each accreditor is going to have its own requirements, and it's important that you comply with them. So when we say due process, we're actually really talking about not just the 14th Amendment due process, that you can't be deprived of life, liberty, or property without due process of law, but also what sort of contractual due process is laid out in your institution's policies. So what is misconduct in an academic medical setting? Meaning, what are we talking about? What are we disciplining for here? This can range from, anything from a code of conduct violation and types of conduct that we think of as misconduct, such as, stealing, to conduct more specific to healthcare and more specific to academic medicine, including HIPAA considerations, research misconduct, and similar types of fraud, failure to comply with clinical expectations, a failure to comply with professionalism expectations, a failure to meet any sort of academic or conduct type expectations of your program. And as I mentioned previously, institutions are given quite a bit of discretion over setting academic expectations and enforcing them. We have a Seventh Circuit case cited here. Courts are reluctant to interfere with the academic affairs and regulation of student conduct in a private university setting. We see this generally in academic medical settings as well. What isn't considered an academic matter when it comes to discipline can be quite broad and is really going to be set by the institution based on its policies and practices. For example, patient safety concerns are an academic matter. We have a case here out of Ohio that involved a occupational therapy graduate student who was dismissed from her clinical placement after committing several patient safety violations. She raised concerns that she filed a lawsuit alleging disability discrimination, saying that her inability to meet these patient safety needs was due to her ADHD and anxiety. The court found that none of the accommodations that she proposed for her disabilities, which included extra time to document the procedures, extra time to complete paperwork, would help her meet the essential requirement of protecting patient safety. And so the court found in favor of the university. Likewise, professionalism expectations are considered academic, so long as those expectations are laid out in the learning objectives for the program or otherwise in the course curriculum somewhere. And in the course, we've seen this play out in a variety of ways. We've seen it in inappropriate social media usage, where a nursing student was removed from a nursing program for unprofessional Facebook posts in which he threatened other members of his program. The court considered this to be an academic disciplinary matter, thus meaning the school had a pretty wide leeway in how to respond to that. I mean, the court was not really wanting to interfere with the school's academic judgment. And the court determined that this was academic in nature because of the Nurses Association Code of Ethics, and the school's determination that the post could ultimately have a negative impact on patient care. The school determined that the student was unable to meet the professional demands of being a nurse based on this social media conduct, and the court refused to overturn that determination. Likewise, we have a case out of Minnesota where a mortuary science student was on social media discussing the human cadaver she was assigned in rude and inappropriate ways, somewhat satirical, but it came to the attention of the school, and the court refused to overturn the university's sanctions against the student, in part because there were plenty of documented professional expectations regarding treating the cadavers you were assigned with respect. So the key consideration we see here is, have professionalism expectations part of your course curriculum and your learning objectives, and then requiring that students program. So how should your institution conduct its disciplinary processes? Generally, where misconduct is reported, it should be investigated, addressed, and remedied. There is no one right way to do this, but it's governed by your written policies. What's important, again, is to ensure that you're giving students adequate notice and an opportunity to respond, and that you're complying with any process requirements required by your accreditor. Finally, discipline is an area where we see a large amount of litigation. We see breach of contract claims brought by students at private institutions, including medical students, nursing students, all sorts of healthcare learners. When they're dismissed, and they bring a claim alleging that the institution did not follow the process laid out in their policies before dismissing them. We also see it with public institutions bringing claims under the Constitution, under the Due Process Clause. Again, we see courts giving a significant amount of discretion to academic dismissals, so long as the school is able to connect the issue for which the student was dismissed to an actual competency or learning objective or part of the curriculum. When it comes to students with disabilities, yes, Annie touched on this earlier too, students with disabilities can be disciplined. That discipline cannot be discriminatory. That is, you can have the same professionalism and other academic expectations for your students with disabilities, and require that the student follow the same academic standards. You must ensure you're giving them adequate accommodations, reasonable accommodations, and that you are not treating them disparately than other students without disabilities. We have a case out of Vermont described on the slide before you, where a fellow missed several months of her fellowship after she had a stroke, had some mental health issues after the stroke, and had a suicide attempt. The academic medical center concluded that she needed at least an additional 6 months to meet the requirement, to meet the learning objectives of her fellowship and to successfully complete it. And it determined that it could not offer her that extension of 6 months due to its own limited resources and some other considerations. And the court ultimately determined that this was an academic decision and not an adverse action based on her disability. So again, this is very fact specific, and when you are faced with making kind of, whether it's a true misconduct disciplinary type decision like Annie discussed earlier with the student who was abusing alcohol on the job, versus something that might be a little more nuanced, where a student needs, is performing poorly academically due to a disability related concern, It's very nuanced, and we encourage you to really carefully consider all of the various factors.
Mary, we have a question that relates largely to this. It's how do we avoid a disability lawsuit from students who might be behaving in a way that gives us concerns for safety when it likely stems from a disability like mental health? So we would call this a potentially dangerous or disruptive student.
Right. So of course we can never promise that someone won't sue. But in short, this is a very short answer, is to focus on the conduct as much as possible as opposed to the disability, right? So you're not suspending or putting a student on a remediation plan or asking them to repeat or dismissing them because of their disability, but because of the conduct they're engaging in. Now, in the higher ed space, the Department of Ed has given some indication that it will offer guidance on dangerous or disruptive students and how to address them while not discriminating against them. But we know that the circumstances that arise in the academic medical setting always present unique facts that don't quite fit into buckets of guidance. So our recommendation is that you preemptively have a plan, such as through a behavior intervention team, train those involved in that team, and use as much care and consideration as you can, while also recognizing that in many situations time is of the essence and you want to respond to any direct threats promptly. All that said, we do find that most institutions eventually err on the side of accepting the risk of a disability lawsuit over trying to avoid that risk so much that you err on creating a risk to campus safety. I do see another question here about whether there's a manifestation determination meeting equivalent. That's an idea from the K-12 space, and there isn't that sort of specific requirement other than what just best practices of having this behavior intervention team who can meet and who's trained to consider dangerous and disruptive conduct. And again, separating the conduct from the disability as much as possible is something we recommend. So before I turn it back over to Annie, I quickly wanted to touch on the ACGME resident leave requirements. These came into effect on July 1 of last year, but they're going to be enforced starting July 1 of this year. So we just want to make sure that for those of you who aren't aware of them already, that you are, and that you're putting policies in place to comply with them. Under these requirements, the resident program must allow a resident at least 6 weeks program. They're entitled to that leave starting day 1 of the program. In addition to that 6-week leave, they must also get at least 1 additional week of paid time off. That paid time off is 100% of the resident's salary for the 6 weeks. They have to continue getting insurance, etc. Now, this doesn't mean that an extended leave can't impact program completion, which it might. So accordingly, your program must provide residents and fellows with information about the impact of extended leaves on program completion and the eligibility to participate in relevant certifying board exams. I'm going to turn this over to Annie now to talk about alternative student funding mechanisms.
Thank you, Mary. And before y'all get excited about alternative student funding mechanisms, I wanted to answer one question that we got about how schools can increase enrollment of underrepresented students in medicine without running afoul of discrimination laws. If you can solve that, please let me know. But the general guidance we give is that when we look at the guidance that's coming out of NSF, NIH, it does define underrepresented in medicine as something more than just race, sex, religion. It does include some unprotected categories. So that's my point of reference when I'm considering guidance to offer to schools. It includes things like socioeconomic class, and to the extent you can do that without making it a direct proxy for race or sex or nationality, consider using that definition when you're considering things like scholarships and targeted programs. My hope is that we will get some very clear guidance from the federal government soon on how to do that. But for now, they just seem to be sleeping on this issue in this sort of scholarship situation and programs designed at increasing representation. Now to the exciting part. Does your institution offer education for work agreements to students in healthcare programs? To explain, those are students, those are situations where often, and this is so common in the healthcare space, an institution, maybe one that's owned by a hospital, will offer a deal where if the student goes to work for the hospital for a couple of years after graduating, then their student tuition will be forgiven. And it's critical to the pipeline of our healthcare workers. I know many people who took advantage of it themselves. I know many institutions that rely on it heavily to grow their next crop of junior employees. And it looks like a fair number of your institutions do offer those programs. The reason we bring this up is that last year, the CFPB and the Department of Education basically said that something called income share agreements are student loans and therefore regulated by the Truth in Lending Act, possibly regulated by state laws around lending, possibly regulated by other federal lending laws. And in an income share agreement, so you know, it's where we have an institution or a private entity extends credit to students to fund their educations. And then when the students graduate and start earning money, they pay back a percentage, and the terms varied. And they said that's a loan because at the time the student starts, they're obligated to a debt, and therefore we should have all the loan protections that come with that. And to abbreviate, I won't read this slide for you because we're short on time. Institutions have basically stopped offering income share agreements or greatly limited their income share agreement plans, or importantly, and to the happy ears of their friendly neighborhood education and consumer finance lawyers, have started issuing compliant income share agreements that are truly drafted as a loan, that consider state laws, that consider the Truth in Lending Act. Let's look a little bit about the factors for a private education loan. It's a loan provided by a private education lender. It's not a Title IV federal student aid loan. It's issued expressly for post-secondary education expenses to a borrower, regardless of whether it's through the student's educational institution or directly from a private lender. And that sounds an awful lot like some of those education for work agreements that our institutions commonly offer and rely on. So the bottom line is, as you are crafting these, particularly if you get Department of Education funds, but even if you don't, you may be subject to TILA and Truth and state consumer protection laws. Be sure that you're drafting those in a way that's compliant. And a recommendation for doing that is really just to be sure you're disclosing information up front. If it's a situation that would be subject to the Truth in Lending Act, be sure you're making appropriate disclosures. Disclose. Make it crystal clear to students what's expected of them. If you're looking to mitigate risk, consider how you will collect on that if a student leaves, because sometimes people need to leave their jobs. And it would be unfortunate for someone who had to leave their job for whatever reason to be saddled with debt that they weren't expecting in some circumstances. In other circumstances where you're making it clear we're dealing with grown-ups, and as long as we're within the bounds of the relevant laws, it's okay to do that. And then another area where we have had some hiccups in recent years, largely due to changes in regulations, are changes of control for institutions of higher education. Keep in mind, healthcare people, an institution of higher education change of control is remarkably more complex on the regulatory side, in terms of timeline in particular, than it can be for a healthcare institution. We have had a few situations where a healthcare institution says, we're closing on a deal in 3 weeks, and we are adding a new holding company to us. The Department of Education, if your institution of higher education, say a nursing school owned by a hospital, takes Department of Education dollars, that would be a change of control. Even if it's a great-great-grandparent new entity, it might be a change of control. to the Department of Education. Every regulator, so not only do we have the Department of Education to answer to, we have accreditors, we have the Veterans Administration, we have state regulators who are critical to the operations of institutions of higher education, and they all have some nuanced regulations. And so keep in mind, even if you don't think of this transaction as a change of control, if you have changes in percentage of your ownership that meet a threshold, if you're merging two schools together or doing an asset purchase and continue the operations of the school, both schools, know that you may need to comply with all of these obligations. Typically, a change of control, and the typical's in quotes because every single transaction is different. You'll enter your agreement. You'll notify your primary accreditors in the Department of Education. You'll carry through with your agreement as you are notifying other regulators. And then you notify the departments after the transaction closes, as well as your other accreditors and regulators. And you have a lot of work on the back end to produce various documents and some restrictions on program growth at the institution of higher education in the meantime. In a perfect world, we would have 18 months to do this. I know that's a long timeline for many healthcare transactions, but if you're even thinking about engaging in one of those transactions, consider checking the regulations on whether that would constitute a change of control for the institution of higher education. There are all sorts of requirements, again, things like not only GAAP audited financials, but you need to have GAGAS audited financials. If you're a private institution that hasn't owned a school before, you may not have that. You may have letter of credit requirements, and the earlier you can get a jump on that, the better. So to wrap up, everything is changing. It's always changing. The law is always changing around non-discrimination. We are on the edge of our seats waiting for those new Title IX regulations and case law around vaccination. Resident leave requirements will be enforced starting July 1st. We're watching the case law around education for work agreements and Department of Education and CFPB guidance there. And the change of control regulations are rapidly changing, as are the expectations of various regulators around that. We hope we've provided some useful information today. Thank you for your time, and I will hand it over to Mary to wrap us up.
I'll just echo Annie in saying thank you for joining us today for this complimentary CLE. We hope this information was helpful to you and your organization. As a reminder, the program has been approved for legal education hours. To report your hours, click on the icon at the bottom of the screen. If you need any help with that, shoot us a message and we can try and help out. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of this webcast for watching and sharing. And finally, be sure to complete our short survey. It's really useful to us if you can take, a couple minutes to do this. We use your feedback to plan future programs that are applicable to your institution's needs. So this concludes our webinar. We hope everyone has a great day. Thank you very much.